If you guys remember, we've already covered Kayla's motion that it was drywall dust, or Nick could have been on Ozempic. Of any number of things that are going on out there. That is Kayla's argument. Well, the prosecutor got a chance to respond, and oh boy, did she respond. Now, it hasn't been denied yet, but this is kind of just a precursor for what we're doing. And this is the state's response and opposition. Now, it's very funny because there's one big problem I have with it, and we'll get to that when we get there. And they say this, and this is the state's memorandum of law in opposition. So they're opposing it. And the sole issue before the court is whether there's sufficient probable cause to support the search warrant. And obviously, they want the court to deny Kayla's motion in its entirety. Now, once again, the U.S. and Minnesota Constitutions provide that no warrant shall issue without a showing of probable cause. And they have their own Minnesota Supreme Court case that reflects on the 14th Amendment and the 4th Amendment. Now, in determining whether or not the warrant is supported by probable cause, the issuing judge's decision is not reviewed de novo, meaning it's not reviewed in its entirety. And instead, great deference is afforded to the judge or magistrate's findings of probable cause. And that's true. Generally speaking, they pretty much are considered to have made the right decision. There's a lot of deference given. And they say to determine whether the judge had a substantial basis, we look to the totality of the circumstances test. And that goes back to Illinois v. Gates. Remember, guys, we talked about this before. There were two tests out there, the Aguilar-Spinelli test and then the Gates test. The Gates test is the predominant one in the United States. There's only 4 or 5 states that do the older, more restrictive approach to getting a search warrant. And they say in determining whether there is probable cause of search, the issuing magistrate's task is to simply make a practical, common sense decision whether, given all the circumstances set forth in the affidavit, there's a fair probability that contraband or evidence of a crime will be found in a particular place. So they talk about this. The courts must ultimately be careful not to review each component of the affidavit in isolation. And that's true. You have to look at it in its entirety. Think of it like a cake. I would use the sandwich analogy, but you could pull the pieces of a sandwich apart. But once you bake a cake, you can't separate out the eggs. You can't separate out the flour. You can't separate out anything. It's all one thing now. You have to look at it in its entirety. Does it make a cake? And they say a collection of pieces of information that would not be substantial alone can combine to create sufficient probable cause. Well, it's like we talked about that. And, she's showing case law that says that, but it's like I've said that before. 1 brick is a brick. 100 bricks is a wall. And the warrant should not be invalidated by construing the affidavit in a hyper-technical rather than common sense manner. Yes, that means sorry out there. If you're trying to act like you're on Reddit and go, well, actually, what does that mean? There could have been a watermark. What do you mean you saw the originals? No. Sorry, it doesn't work like that. It doesn't work like that. Now, I don't like this part. Doubtful or marginal cases are resolved in favor of upholding the warrant. I think that that's actually a problem. I think that, there should not be the burden given to the person finding. I think it should be tough. I think the Aguilar-Spinelli test is far more effective at protecting liberty interest. So this idea that doubtful or marginal cases are resolved in favor of upholding the warrant, doubtful or marginal cases should be resolved in favor of the person who's going to have their shit searched. That's the right way to uphold that. This right here, I think, is just, obviously a court's never going to agree with me, but I think this is actually a bullshit idea. Now, the warrant must supply specific facts to establish a direct connection or nexus between the crime alleged and the place to be searched, particularly in cases involving the search of a residence for drug activity. And they say, direct observation of evidence of a crime at the place to be searched is not required. Meaning the cop doesn't have to sit there and peep in the window and see the drugs. The nexus may be inferred from the totality of circumstances, including type of crime, nature of the item sought, extent of the defendant's opportunity for concealment, and normal inferences as to where the defendant would usually keep the items. And once again, when you got drugs, you might keep them in your thing. Now, they say a finding of probable cause may rest upon evidence which is not legally competent in a criminal trial, and that's true. You can have hearsay. You can have completely inadmissible hearsay. You can have hearsay that's double hearsay. As long as it's reliable, it can still be used. Now, you would have problems about introducing the hearsay at trial, but remember, you get a little bit of leeway because otherwise the police would never get anything done. Now, some of you might say that's a based idea, but the court's never going to let us get there. Once again, it's like getting machine guns. We're never getting them. Officers may rely on their training and experience to draw inferences. And the reviewing courts may only consider the information in the application for the search warrant. And the neat thing is, for Kayla and Nick, we have the application for a search warrant from Detective Pomplin. So we've got that, and we're going to go through that again. Now, they start off, and here's where it starts picking up. The affidavit for the search warrant begins with a child maltreatment report that was taken by Sergeant Nestor relating to controlled substance use by the defendant's husband. Once Detective Pomplin received the report, he began an investigation into whether or not there was criminal activity related to drugs. The name of the reporter or the relationship was not included in the affidavit. Now, this is great. However, the name of a reporter of child maltreatment may not be disclosed. Oof. Remember that the whole time. You're not telling who did it. State law doesn't let you. No. Oof. Oof, chat. Your laws and your rules, you got to follow them. You got to know them. The report was the basis of law enforcement's investigation. Yes, it was. It was not the entire investigation, nor the sole basis for the application of the search warrant. And it's this part here. Kristen Pierce, if you're out there and you know from the Kandiyohi County prosecutor's office, just if you're out there, I appreciate this. Even if the court were to strike the information about the child maltreatment report from the application, there is still probable cause for the search warrant based upon Detective Pomplin's investigation. Ooh. If the court were to strike the information about child maltreatment from the application, there's still probable cause. Ooh. The funny thing is, it's like I've mentioned that before. It's like I've said that before. Just like, based on my experience and practicing and figuring things out, it's like I kind of knew this. It's like I kind of already said this. It's like great minds think alike. And here's the thing. I'm not even thinking as a great mind. But once again, chat, let's get back to this. Let's get back to this and see where Nick's going to probably claim she's absolutely bullshit lying. Fuck off.